Well, the simple answer is yes. The creditor can file multiple adversary proceedings, but the creditor runs the risk of being viewed as a vexatious litigant. There is the old Woody Guthrie song, and I'm probably going to garble the lyric. It's I think the name of the song is Pretty Boy Floyd, and the lyric is, "Some men will rob you with a six-gun, others use a fountain pen." Sometimes a creditor just decides it's going to beat down the door of the debtor with multiple adversary proceedings. In other words, rob them with a fountain pen. If there are genuinely different types of adversary proceedings against the debtor that this creditor is filing, then the creditor may be able to succeed. But if it's essentially the same thing and what the creditor is seeking to do is just beat down the debtor, that creditor may not only lose, but be subject to sanctions for abusing the bankruptcy process. And that enters into a fascinating realm that is within unsettled law. And in fact, I have a case that has this particular scenario where I represent a debtor, and there is a creditor that filed multiple adversary proceedings over the space of years. In each adversary proceeding, the creditor lost. And it was clear that this was nothing more than pure vexatious litigation. And there are a couple of directions that the debtor can go in this situation. Number one, the debtor can appeal to Section 105A of the Bankruptcy Code. And there is something in the Bankruptcy Code that says that the bankruptcy court has the authority to make sure that things run smoothly and that there is no abuse of process. I've just extracted a little bit of that section. There is some question over whether the debtor has standing to mount such an adversary proceeding, or if it has to be the judge sua sponte sanctioning based on this vexatious litigation. The second direction steps outside of the Bankruptcy Code into 28 U.S.C. Section 1927. It's a very short section. And what it says is that if an attorney multiplies filings against a party vexatiously, then that party can get damages, including costs and attorney's fees against the attorney. So that seems like it would be a pretty obvious direction to go. The one drawback is, and here we have a split among the federal circuits, in the Ninth Circuit, a bankruptcy court is not considered a court of the United States. And that statute, 28 U.S.C. Section 1927, refers to courts of the United States. The wording of that statute is a little bit unclear. I think the Ninth Circuit may want to revisit that particular holding. But in any event, even though the bankruptcy court is a federal court, it's a court established under Article 1 of the U.S. Constitution rather than Article 3. Article 1 describes the powers of the legislative branch and other things associated with the legislative branch. Article 3 deals with the judicial branch. In Article 1, Congress has the authority, among others, to develop uniform laws on the subject of bankruptcies throughout the United States. Pursuant to that law, Congress has enacted the Bankruptcy Code and also established bankruptcy courts. But they're Article 1 courts. And so the Ninth Circuit said, no bankruptcy court is a United States court. It may be a federal court, but it's not a United States court because those courts are established under Article 3. There is a split among the circuits, and I think this might be a time where an appeal will go up to the U.S. Supreme Court to resolve this split. My own feeling is I think the Ninth Circuit got it wrong, but that and a couple of dollars will get me coffee at Starbucks. Somehow we've got to get the U.S. Supreme Court on board, and the problem with them is they don't take very many cases each year, maybe 60 to 70 cases a year. And not all bankruptcy cases. They may take one or two bankruptcy cases in a year, if that many. And remember, they're taking cases from all over the country, including criminal cases, patent cases, trade cases, all kinds of stuff. So whether the Supreme Court would take this up is unclear. But the one hook that can be used is when there's a split among the circuits, the Supreme Court is more likely to take the case because that constitutional provision that enables Congress or empowers Congress says that Congress has the power to establish uniform laws on the subject of bankruptcy. So if you have a split among the circuits on the interpretation of a bankruptcy statute, you no longer have uniform laws. In any event, the creditor certainly can file multiple adversary proceedings against a debtor, but the creditor runs the risk of being labeled as a vexatious litigant, and that can be an expensive proposition to deal with.